Illinois' gun and magazine ban is on hold after a federal judge issued a preliminary injunction against the law. What's going on? Greg Bishop here, and even though I'm off for the week, back live on Thursday, wanted to get out this update because people have been waiting for this one. Federal judge blocks Illinois' gun and magazine ban while the case continues. This is the latest in a string of news that came out of Illinois' gun litigation. You had earlier this week a judge denying a Chicago doctor's attempt to block Illinois' gun and magazine ban. That was in the Northern District. You also had the Naperville case go to the U.S. Supreme Court and ask for the gun ban to be blocked, while that case is pending in the 7th Circuit Court of Appeals. But on Friday, you had a federal judge block Illinois' gun and magazine ban while that case continues. And I'll just read from the story I put out really quick. Illinois' gun and magazine ban's on hold after a federal judge of the Southern District of Illinois ruled in favor of a preliminary injunction. The case could be appealed to the 7th Circuit Court of Appeals, where a similar challenge is pending. Now, one thing to note, this is a preliminary injunction. This is not on the merits of the law. That is still has to be hashed out, but this is ongoing litigation, and it looks like you've got the law that was enacted January 10th now on hold. Friday, Judge Stephen McGlynn granted a motion for a preliminary injunction blocking enforcement of the law statewide, saying that plaintiffs have satisfied their burden for a preliminary injunction. They've shown irreparable harm with no adequate remedy of law, a reasonable likelihood of success on the merits, that the public interest is in favor of the relief, and the balance of harm weighs in their favor. Therefore, the plaintiff's motion for preliminary injunction granted. Defendants are enjoined or kept from enforcing Illinois' statutes, the Protect Illinois Communities Act, and says that that's going to be statewide during the pendency of the litigation until the court can address the merits. Now, I did reach out to Governor Pritzker's office and the Illinois Attorney General's office. Didn't immediately get a response. We'll see what they have to say as this continues to go on. But things are going to get interesting. As I said, you've got a case out of Cook County where a judge there in the Northern District decided to side with the state and the county. Then you also have the case out of Naperville where that was ruled on back in February, where the judge ruled in favor of the state. And that's in the 7th Circuit Court of Appeals. It's expected the Southern District case will go to the 7th Circuit Court of Appeals as well, where things could get rather interesting. So, again, the top line here is that Illinois' gun ban is on hold after a federal judge blocked the ban pending ongoing litigation. So that's a bit of an update here for you on this Friday evening. Heading into the weekend, you're going to hear a lot more about this and a lot of analysis, as the ruling itself is a good 30 pages. And just to kind of go over some of the various particulars. Number one, this is in the Southern District of Illinois. This has nothing to do with the state level cases. This is a federal case. But this is the 4 plaintiffs groups. You had the Langley case that came out of Crawford County. You have the Illinois State Rifle Association. You have the Federal Firearms Licensees of Illinois, and also the National Shooting Sports Foundation. All 4 cases consolidated, and it was heard April 12th, so just a few weeks ago, in the Southern District of Illinois. And Judge Stephen McGlynn, he heard that case, and he put together this order talking about the standing, talking about the challenges that were brought forward, the legal standing for injunctive relief, the analysis of that injunctive relief, talking about irreparable harm, goes into detail about what plaintiffs argued and what defendants argued, says there's no adequate remedy of law for the plaintiffs, saying that they're being harmed by this ban, and also says that they have a likelihood of success on the merits. So you go through and you read through the plaintiffs in the defense arguments that the judge parsed through and provided. And again, you can read all of this at thecentersquare.com. Find me on Twitter, where you can also see the story in the link. You can actually click through and read the order yourself. But as you go through, you could see a lot of the analysis deals with previous Supreme Court precedents, the New York State Rifle and Pistol Association versus Bruin, and the idea that you cannot ban commonly held firearms. So one thing that is interesting about the difference here is McGlynn in the Southern District issuing this preliminary injunction, different from the Northern District Judge, Virginia Kendall, who in February ruled against Robert Beavis from Law Weapons that was challenging Naperville's ban. And one of the things that the judge there said was that the state met the burden and that the banned firearms are dangerous and can be banned under the history and tradition of how the U.S. regulates firearms. McGlynn saw that differently. He said although defendants challenged the veracity of the plaintiff's evidence, they were unable to produce evidence showing that modern sporting rifles are both dangerous and unusual. Consequently, defendants failed to meet their burden to demonstrate that the arms banned by the Protect Illinois Communities Act, that's the gun and magazine ban, are dangerous and unusual and thus not protected by the Second Amendment, McGlynn wrote. So this obviously is all going to go into the Seventh Circuit Court of Appeals. What happens next? We'll be tracking this for you, but again, a little bit of an update here, a big update heading into the weekend. Hopefully everybody has a wonderful rest of the week.